Kristen Clarke is the president and executive director of the Lawyers Committee for Civil Rights Under Law, one of the nation's most important and long-standing civil rights organizations. She previously ran the Civil Rights Bureau for the New York Attorney General's Office, worked at the NAACP Legal Defense and Education Fund, and at the Civil Rights Division of the U.S. Department of Justice. As I said before, she's an old and dear friend, and it's an honor to have Kristen here today. Thanks, Kristen.
Thank you, Dew. I was just about to call her by her last name, which is what I've done for years. Thank you, Moon Ducha, and thank you for putting together what I think is truly a historic gathering and one that will go down in the history books. During these dark times, for me, I find encouragement seeing people from all walks of life and from all sectors thinking about how they can bring their expertise to bear to help deal with some of the challenges that we face in our democracy today. So it really is an honor and a pleasure to be a part of this. So yesterday marked the 52nd anniversary of the Voting Rights Act of 1965, and I feel like the Voting Rights Act lies at the heart of a lot of the issues that we've been talking about this morning and that will be discussed throughout this convening. So the goal of my talk is to provide some context and history for some of the principles that you have been learning about and will learn about over the course of the next few days. I'm going to do a few things during my talk today. I'm going to provide a historical overview of the Voting Rights Act. I'm going to talk about some of the legal and constitutional challenges to the Voting Rights Act. I'm going to talk about Congress's 2006 reauthorization of the Voting Rights Act. I'm also going to talk a little bit about a very important 2013 Supreme Court decision which got the heart of the Voting Rights Act, a case called Shelby County, Alabama v. Holder. And then I'm going to close by talking about a wave of voter suppression laws and efforts that sadly we are seeing across the country that I think really present a moment for many of you all in this room to mobilize to help counter some of the challenges that we face in the wake of the Supreme Court's ruling which gut the Voting Rights Act. So, the Voting Rights Act. How many of you all know much about the history of the Voting Rights Act, just by a show of hands? Okay, great. So this is one of our nation's most important federal civil rights laws. It was passed by Congress in 1965, and it's a law that came about because of the demonstrations and protests that were carried out by people like John Lewis. And there was one march in particular during the 60s, a march from Selma, Alabama to Montgomery, Alabama, where peaceful demonstrators were preparing to cross the Edmund Pettus Bridge when they were attacked by police officers armed with bully clubs and dogs. John Lewis, pictured at the bottom right of this image, was struck across the head and still bears scars from this incident today. But the peaceful marches and protests from the Civil Rights era are what gave rise to the Voting Rights Act. These images were televised across the globe and really became an impetus for Lyndon B. Johnson to act and to take action. And what Congress did is they put together a law that has a lot of strong medicine and a lot of strong teeth. The Voting Rights Act contains several provisions that we use in the context of redistricting litigation today. One provision of the Voting Rights Act banned outright literacy tests and grandfather clauses and other statutory tools that have been used to disenfranchise minority voters. But the Voting Rights Act contains some other strong provisions that I'll talk about in just a moment. The law was passed by the Senate on May 26, but Lyndon B. Johnson signed the bill into law on August 6th of 1965. Martin Luther King and others were present for the signing ceremony, and so in many respects, it's great to be up here today talking about this remarkable law. There is a provision in the Voting Rights Act known as the Section 2 provision. This is a provision of the law that applies nationally, and it prohibits states and localities and jurisdictions from putting in place laws that may dilute minority voting strength or deny minority voters access to the polls. So litigators often work with statisticians to use Section 2 as a tool to challenge redistricting plans that fail to provide minority voters an equal opportunity to elect candidates of choice. There's another provision of the Voting Rights Act that has sadly been the subject of a lot of controversy in the courts, the Section 5 preclearance provision. At the time that this law was put into place, there were some parts of the country where voting discrimination was intractable and truly a problem that required strong medicine to uproot. Alabama was one of those places, Mississippi, Louisiana, South Carolina, parts of North Carolina, Texas, Arizona, parts of California, Florida, parts of New York. All of these states, 16 in total, were subject to this one very special provision of the Voting Rights Act that essentially said that before you can make any change to any voting law or any procedure concerning voting, you have to get federal review for that voting change so that we can be sure it's a change that won't worsen the position of minority voters. It's a law that was intended to make sure that jurisdictions didn't turn the clock back and worsen the position of minority voters. This special provision of the law, of the Voting Rights Act, has literally helped to block hundreds of discriminatory voting changes, including discriminatory redistricting plans over the course of the past few decades, and I'll talk more about that. But both of these provisions of the Voting Rights Act, again, have proven key in many redistricting battles when it comes to race in our country. So this is a really unique law. The Section 5 preclearance provision that I mentioned is a law that was temporary. Congress put it into place for 5 years in 1965 and then came back again in 1970 and said, you know, we really haven't made much progress yet. There's still a lot of work to do. They renewed the law again in 1970 for another 5 years. Same thing, not a lot of progress had been made, still a lot of work that needed to be done. They decided to go to 7 years to 1982, arrived at the same determination, and so they renewed the law again for another 25 years in 1982, bringing us to 2006. Congress began to commence hearings to examine the law, the need for the law, again in 2005, 2006. This is an image of Congressman Sensenbrenner, a Republican in the House, who was a real champion for renewing Section 5 when it came before Congress in 2005 and 2006. At the time that the law came up for renewal, there were a lot of states that said, you know what, a lot of members of Congress who thought, you know what, we're post-racial, we really don't need this law anymore. There's been a lot of progress. We just don't think we need this law anymore. But Congress moved forward and held a number of hearings, close to 24 hearings. They heard from dozens of witnesses on both sides of the aisle. And at the end of that process, something very clear came to light. The Voting Rights Act was continuing to do work in the present day to block and deter discriminatory voting changes, discriminatory redistricting plans that were being put in place or that were sought to be put in place throughout the 16 states that are covered in whole or in part by the law. There was a moment when the House was fully debating the need for reauthorizing Section 5 of the Voting Rights Act, and I remember Congressman Sensenbrenner began to pile the books, the legislative record that had been amassed onto a table, and some of the books started to fall onto the floor, but it really was a very powerful illustration of this Congress doing its job, doing its homework, to really study carefully the need for an important law like this. And just a tremendous record filled with examples of ongoing voting discrimination developed before Congress. At the end of the day, the law was reauthorized, 98-0 in the Senate and 390-33 in the House. So by an overwhelming bipartisan margin, almost unanimous, on the Senate side, Congress agreed at the end of the day that we still needed Section 5 of the Voting Rights Act, that it was still playing an important role in our democracy. Examples of some of the kinds of discriminatory voting changes that were blocked included redistricting plans that packed minority voters unnecessarily into districts, denying them the ability to have influence outside of those districts, redistricting plans that cracked minority voters, also denying them the opportunity to elect candidates of choice in particular districts. But then there were other voting changes. Kilmichael, Mississippi provided one powerful example of how Section 5 operates. This is a small community off the beaten path in Mississippi where census data had revealed that African Americans had become a majority of the population. It's a town governed by a 5-member council and a mayor, all white throughout the town's history, but because of the demographic shift, a number of African Americans decided to qualify and run for seats on the council and run for even the mayoral seat. And the council decided to change the rules of the game. They voted to cancel the election. But because that decision to cancel the election was a change impacting voting, they had to submit that change to the Justice Department that saw through and saw what the clear and real motives were underlying that decision, and they objected to the change and required the town to go forward. And for the first time in the town's history, they ultimately elected a majority of African Americans to 3 of the 5 council seats and elected an African American mayor. But for Section 5's kind of preemptive strike, discriminatory voting changes and laws and redistricting plans would have gone into place, into effect in many communities across our country. So this is a law that's done some remarkable work to help open up access to democracy across our country. Now, days after the bill was signed into law, constitutional challenges were filed against Section 5. The first such challenge was brought by, you see here a picture of Edward Bloom. He is somebody who is an ardent opponent of policies that seek to right historical wrongs. He's somebody who opposes the Voting Rights Act. He's someone who opposes race-conscious admissions policies in the higher ed context. But groups like him have been architects of legal challenges that have sought to tear down the Voting Rights Act. The first case challenging Section 5 after it was last renewed was a case brought out of Texas, a case called the Northwest Austin Municipal Utility District Number 1 v. Holder. It's a long caption. But in this case, this small utility district argued that there were states' rights concerns here, and federalism arguments were raised, and they argued that we were in a post-racial world. And that case ended up moving through the courts, through the district court, and eventually up to the Supreme Court, and resulted in a decision issued in 2009 in which the Supreme Court ultimately left Section 5 in place. And I have a short audio clip that I'm going to try to play for you. This is Justice Roberts reading the ruling of the court in this case.
This is a case about the obligations imposed by Section 5 of the Voting Rights Act. That statute requires all covered jurisdictions to seek pre-clearance from federal authorities in Washington, D.C. before they can change anything about the way they hold elections. That requirement applies only to certain covered jurisdictions selected by a formula Congress created 35 years ago. When the Act was passed in 1965, the pre-clearance requirement was intended to last for 5 years. Congress has repeatedly extended it. Most recently, in 2006, Congress extended it for 25 years. The appellant is a small utility district with an elected board. There's no evidence that it has ever discriminated on the basis of race in those elections. But it is located in a covered state, Texas, and therefore is required to seek pre-clearance before it can change anything about its elections. Another part of the Voting Rights Act, called the bailout provision, allows a covered political subdivision to file a lawsuit in federal district court and to be released from the pre-clearance requirements if certain conditions are met. The district filed such a bailout suit. The district also argued in the alternative that if the Act does not permit it to bail out, the pre-clearance requirement of Section 5 is unconstitutional. The federal district court rejected both claims. It concluded that bailout is available only to a narrow class of political subdivisions defined in the Act, not to an entity like the district. It also concluded that Section 5 was constitutional. The utility district appealed, and we are therefore required to review the district court judgment. Unlike the situation with most of the cases that come before us, we do not have discretion to decline review of cases arising under these provisions of the Voting Rights Act. The historic accomplishments of the Voting Rights Act are undeniable. When the Act was first passed, unconstitutional discrimination was rampant, and the racial gap in voter registration and turnout, that is, the gap between white registration and turnout compared to minority registration and turnout, was great. Today, that gap has been dramatically diminished, and most of the barriers to equal voting rights have long been abolished. At the same time, Section 5 intrudes on the covered jurisdictions in a way otherwise unfamiliar to our federal system. That aspect of the Act has, over the past 40 years, caused various members of the court to express misgivings about the constitutionality of Section 5.
So in the interest of time, I'll stop there. But basically, Roberts presents a very optimistic and rosy view of the world in which we live in today. But ultimately, he avoided the constitutional question in this case, which is something that is reflective of his jurisprudence, where he can avoid taking on important constitutional questions. He'll do so, and he did so in this case, and found that this utility district was a small subdivision eligible to apply for what's called a bailout. And if this jurisdiction could show that it had a clean bill of health for about 10 years, then it could move to terminate its status as a jurisdiction required to get voting changes pre-cleared through the federal government. And so that's ultimately what this utility district did, and that case went away. And what was critical about that case is that the decision happened in 2009, and it's a case that took about 3 years to play out from beginning to end, but it meant that we had Section 5 in place for the 2010 round of redistricting, at least for those first few years. So it was a really big victory in that regard. Civil rights lawyers by no means expected that the constitutional challenges wouldn't continue to come, but these cases do take a while to kind of percolate through the courts. Not every case makes its way to the Supreme Court. So it was a very important victory in that regard. Now we move to the next subsequent constitutional challenge that did find its way to the Supreme Court. This case, Shelby County, Alabama v. Holder, is really critical for many of the issues that we are talking about during this convening. This case was heard by the Supreme Court in 2013, in the spring of 2013, right? So we got through a lot of those first few years of the decade with Section 5's protections in place. The irony about this case is that it emerged from the state that is regarded as the birthplace of the Voting Rights Act and ultimately proved to be a state that put the death knell in the Voting Rights Act. Here, the litigants mounted a very similar challenge. They argued that the Voting Rights Act imposes federalism cost, that we are post-racial, the discrimination is a thing of the past, but Shelby County, Alabama is a place where there had been Section 5 objections. So there had been voting discrimination literally blocked by this law in this very community. In 2011, I presented argument to the DC District Court in this case, along with the Justice Department, and we fortunately got a ruling from Judge Bates, a Bush appointee, who upheld Section 5 as constitutional based on the extensive record of ongoing voting discrimination that had been amassed by Congress. The case then moved to the appeals court, where a 3-judge panel upheld the law by a margin of 2-1, and then the case advanced to the Supreme Court. Now, I talked about the 16 states that are subject to Section 5. There's a provision of the Voting Rights Act known as the coverage provision, the coverage formula, that identified those states that had really long and egregious histories of voting discrimination that warranted that they be subject to this special federal provision of the law. Here, the litigants were challenging that bailout provision and challenging the Section 5 preclearance requirement. The court, in a ruling that was decided by a margin of 5-4, found that the coverage formula was unconstitutional, and that basically brought the Section 5 preclearance process to a grinding halt. If I could get the microphone again, I want to play a short segment from the argument that drew gasps from many of us who were present in the court for the argument.
I'm sorry, were true even back in the city of Rome, because, of course, the tests and devices were eliminated by the statute, so no jurisdiction could have tests and devices, and the city of Rome itself said that the registration problems had been very substantially ameliorated by then, but there were additional kinds of problems. The ascent of these second-generation problems was true even in the city of Rome as a justification that made it congruent and proportional. And we submit that it's still true now, that Congress wasn't writing on a blank slate in 2006. Congress was making a judgment about whether this formula, which everyone agrees, and in fact, Mr. Ryan's case depends on the proposition that Section 5 was a big success.
Well, maybe it was making that judgment, Mr. Verrilli, but that's a problem that I have. Look, this court doesn't like to get involved in racial questions such as this one. It's something that can be left to Congress. The problem here, however, is suggested by the comment I made earlier, that the initial enactment of this legislation in a time when the need for it was so much more abundantly clear was in the Senate. It was double digits against it. And that was only a 5-year term. Then it was reenacted 5 years later, again for a 5-year term, double digits against it in the Senate. Then it was reenacted for 7 years, single digits against it. Then enacted for 25 years, 8 Senate votes against it. And this last enactment, not a single vote in the Senate against it. And the House is pretty much the same. Now, I don't think that's attributable to the fact that it is so much clearer now that we need this. I think it is attributable, very likely attributable, to a phenomenon that is called perpetuation of racial entitlement. It's been written about whenever.
So that literally drew gasps in the courtroom to hear the late Justice Scalia describing the Voting Rights Act as racial entitlement. You know, he also, if you listen to the audio, discredits the margin by which Congress renewed Section 5, 98-0. He kind of suggested that no member of Congress or of the Senate was free to vote against this thing. Interestingly, Justice Scalia, during his own nomination hearing, was voted in by a margin of 98-0. But this ruling is one that truly has changed the landscape dramatically. This is a game-changing moment for those of us who care about the right to vote and care about the health of democracy. Because literally on the day that the Supreme Court issued this ruling, we've seen the floodgates of voter suppression open across our country. The state of Texas, on the afternoon that the court issued this ruling, announced that it was moving forward with a restrictive government-issued photo ID requirement for voters. And this was a law that had been blocked by Section 5 when it was in place. So states literally raced out the gate with all kinds of measures to make it harder for Americans to vote, and we've not seen those efforts slow since the day that the court issued this unfortunate ruling. The impetus is now on Congress to go back to the drawing board and restore the Voting Rights Act. Restore the VRA is a hashtag I encourage you to use. But we see that this is a Congress in deadlock and a Congress that hasn't sadly been able to get a lot done when it comes to, particularly when it comes to civil rights. So needless to say, there's been little movement there, and what we now face is a world in which we are forced to mount slow, case-by-case litigation to challenge every unlawful redistricting plan or voting measure that states or localities seek to put in place. Texas's photo ID. Now, many of you in this room, I'm going to guess, have a passport or a driver's license. Just by a show of hands, how many of you have a passport or a driver's license? When we talk about photo ID and who is impacted, we're not talking about folks who are mobile, folks who drive, folks who fly. We are talking about the poorest Americans in our country who live on the margins, people who are invisible, people who are not under a spotlight. We pulled in the help of experts to analyze who was impacted, and what we found is that there were 600,000 people who were disenfranchised on the day that this law went into effect. Poor people, a disproportionate number of whom are African American, Latino, elderly, who function day to day without one of the forms of qualifying ID. Interestingly, a conceal and carry permit also qualifies under Texas's scheme, but a student ID does not. And if you look at who has a conceal and carry permit, and we pulled in expert evidence to look at this, there are about 75% of people who hold conceal and carry permits in Texas are white men. So there are some gendered impacts here as well. We looked at the cost associated with getting ID. To get some of the underlying documents that you need, the cost could range anywhere from $23 to $47. And these are significant out-of-pocket costs for people who live below the poverty level in our country. And in our view, any rule that makes it harder for Americans on the margins to vote and have their voice heard is something worth fighting for, something worth fighting against. North Carolina is another state. About 2 weeks after the Supreme Court issued the ruling in the Shelby County case, they moved forward with what we describe as a monster voter suppression law. This is a law that sought to make it harder to vote in every respect imaginable. They cut early voting opportunities down from 17 to 10 days. They eliminated pre-registration opportunities for 16 and 17-year-olds. They eliminated same-day voter registration. They changed their ID laws. And they also changed rules that allowed eligible voters to cast ballots out of precinct in their community. So in any way they could have made voting difficult, that's what they did in the state of North Carolina. And a law like this is one that would have been blocked if we had Section 5's protections in place. Now, some of you may have heard about a ruling that was issued last summer by the Fourth Circuit Court of Appeals. The court found that North Carolina's law basically discriminated against minority voters with almost, quote, surgical precision. And the court arrived at that determination because they found that state legislators asked for data on who availed themselves of the opportunity to early vote in North Carolina. They got the data and found that African Americans were early voting at historic numbers. There was a move called Soul to Polls in North Carolina where people would go out after church on Sundays and vote. They saw who was early voting, and seeing that data is what led them to slash early voting opportunities in the state. So it is that act and the way that the state used data and marshaled data that led the court to arrive at this decision that the state had acted with almost surgical precision. And I think I highlight this because it really underscores the critical role that experts play in these cases. Beyond Texas and North Carolina, we've seen the resurgence of voting discrimination at every level. In 2013, Galveston, Texas, put in place a local redistricting plan for justices of the peace that eliminated majority-minority districts. This is a plan that was blocked by Section 5. Without Section 5's protections in place, they've moved forward with the law. And where does that leave us? That means in each and every instance, again, we have to mount case-by-case litigation to challenge these laws, and sometimes we have to live with this very uncomfortable reality in which we have to allow the discrimination to actually take root so that we can develop a record to take into court to say, see, we can demonstrate and show you that this is hurting minority voters. So there's an all-out assault on the right to vote happening across our country, which again is why being with all of you is incredibly encouraging and exciting to see today. When we talk about redistricting, we've got to remember that we're not just talking about congressional districts, we're also talking about state legislatures and city councils and county commissions and school boards. All of these entities will soon engage in redistricting once the 2020 round of census data is released. When we had Section 5 in place in the 16 states that were partially covered, there were 8,000 jurisdictions that engaged in some form of redistricting that was subject to federal review. So as we now move into 2020, we are bracing for a moment in which 8,000 jurisdictions will be engaged in redistricting for the very first time without the protections of the Voting Rights Act in place. The deterrent effect of Section 5 is undeniable. Because officials knew that the redistricting plans they would prepare would be subject to Section 5, sometimes that had a curing effect on the mischief that might otherwise occur. So we are, bracing for the worst as we move closer and closer to 2020. But beyond redistricting, we're also seeing an assault on the Voting Rights Act play out in different ways. In a number of places across the country, we're hearing vote fraud, fear about vote fraud being used as a pretext to justify a number of measures that may make it difficult and can certainly make it more difficult for people to vote. Vote fraud is what Texas used to justify their photo ID law. Vote fraud is what we are also seeing officials use to proffer another suppression tactic, proof of citizenship requirements. For decades across our country, we've had a voter registration system in which we all complete voter registration forms and we sign under penalty of perjury that all the information we present is accurate. Now we have folks who are claiming that we have undocumented Americans going out into polling sites seeking to turn the outcome of elections in our country. We know that these claims are baseless. The last place you'd find someone who is undocumented is interacting with government officials inside a polling place on Election Day. But vote fraud is the justification used for a lot of the suppression measures that we see today. Here I have an image of Chris Kobach. He is the Secretary of State in Kansas, a meeting with the president. He's holding a plan to gut another important voting rights law called the National Voter Registration Act. But that aside, the president appointed him to chair what's called the so-called Election Integrity Commission. This is a federal commission that was recently launched that purports to go across the country and look at the problem of vote fraud and to find ways to prevent fraud from happening across our country. We call this commission the sham voting commission because we believe that it is a tool ultimately being used to promote voter suppression laws and efforts, photo ID, proof of citizenship requirements, and other barriers that will make it harder for people to vote. But I wanted to take a moment to talk about this because of some of the math involved here. Chris Kobach is a proponent of a program called Crosscheck. And what Crosscheck is, or holds itself out as, is a program that can be used to identify people who are registered to vote in more than one state. And he's found a few states that have voluntarily participated in his effort and turned over their voter data to him, and he claims that he has the ability to identify matches, people who have the same name and date of birth, who must be the same person registered to vote in more than one state. A number of academics who have looked at the Crosscheck program have found that it has about a 99% error rate. And there was one study that I want to highlight called One Person, One Vote, estimating the prevalence of double voting in U.S. presidential elections. And it was a study put out just a few months ago by Sherrod Gohl at Stanford, Mark Meredith at UPenn, Michael Morse at Harvard and Yale, David Rothschild at Microsoft, and Hushamand Shirani, Mayor at Stanford. And what they found is that it is just quite common that you have folks who have the same first name and last name and date of birth, that you have names that of similar popularity that arise during particular periods of time, that there's just a high error rate in this Crosscheck program. And the Pence-Kobach Commission that has been launched has asked secretaries of state across the country to produce data on every single American in the country. And what we fear is that Chris Kobach intends to use that data to not only advance voter suppression efforts, but to feed it into this highly error-prone Crosscheck program that he has been pushing for quite some time. So this is part of the assault that's happening on voting rights in our country. So let me close out by just saying a few things about redistricting. So far this morning, we've talked about traditional redistricting principles, things like compactness, how important it is to have districts that are compact and districts that respect geographical boundaries. I think it's important, and as a civil rights lawyer, I want to impart this message, important to remember that sometimes these principles are secondary to the important work that must be done to ensure that minority voters have an equal opportunity to elect candidates of choice in our country. There's no one-size-fits-all approach to redistricting, no cookie-cutter approach to redistricting that will truly work. This work is hard and really requires an intensely localized inquiry into what's happening in a particular community. What are the socioeconomic variables at play? Is there a high poverty rate that influences turnout rates among minority voters historically? Is there a history of official discrimination? Is voting deeply racially polarized, meaning do white voters often as a bloc to defeat candidates of choice who are backed by minority voters? Close and careful analysis of all of these factors is really critical to determining the point at which you're providing the minority community a fair and equal opportunity to elect candidates of choice. And if we want a fair and inclusive democracy, it requires that we roll up our sleeves and do that hard work and conduct those intensely localized inquiries. I also want to talk about one other crude practice that we are seeing in a few communities across the country, and that's mid-decade and late-decade redistricting. Now, historically, communities engage in redistricting at the start of a decade, once we have new official census data that tells us how the demographics have truly changed over the course of 10 years. But in some areas, we're seeing officials go back to the drawing board and open up redistricting plans 7 years into the decade. Often this is done for nefarious purposes. And one particularly bad actor in this regard is the state of Georgia. We actually just filed suit against the state of Georgia for engaging in what we deem to be unlawful racial and partisan gerrymandering. Let me give you a little bit of what we encountered here. They opened up their redistricting plan in 2015 and carved out chunks of the minority community in several parts of the state that have seen demographic shifts over the last few years. There's a 180-member legislature in place in the state of Georgia. One example of what they did arises in District 105. District 105 is a district that, at the time when they redrew boundaries after the 2020 census, District 105 had a white population of 48.6% and a combined Black and Latino population of 51.6%. In a 2012 election, the two candidates, the incumbent, backed by white voters, and a challenger largely backed by minority voters, there was a 554 vote difference, a margin of 2.7 points. And the state has gone back in and increased the white population by 4.3% and reduced the Black and Latino population by 3.8%. When they did this, we found that the white incumbent defeated the Black challenger in November 2016 by 222 votes. It's our view that, but for going in and adding in that 4.3% of white voters and pulling out that 3.8% of Black and Latino voters, that the natural outcome is one in which the incumbent likely would have faced defeat. And we've seen that similar pattern in a few other districts that were altered mid-decade in the state of Georgia. But again, we had to kind of play it out. We had to let it play out. They did this in 2015, but we had to wait for some elections to take place in order to develop a record that we could very confidently bring to court to say, here is an example of a discriminatory gerrymander that happened in the middle of the decade in the state of Georgia. It's a practice that I wanted to flag that I think we need to keep our eye on, particularly given the fact that we're not operating in a world with Section 5 of the Voting Rights Act in place. Here, there were all kinds of departures from normal practice and procedure. There was no debate, no substantive or rigorous debate. about the changes. They were described as innocuous when that absolutely wasn't the case. No community input was sought, which is typically something done during the course of redistricting. Minority legislators were not consulted on the changes. A redistricting committee was not convened, though there is one in place. They attempted to kind of put all of this in place under cover of darkness. And so now we're suing, and it'll be a few years before we see a final outcome in that case. But again, a practice that I think we need to all keep our eye on. So why does all of this matter? I believe that fair redistricting has a direct correlation on the quality of people's lives in our country. Whether you care about issues like the school to prison pipeline, having a school board that fairly reflects the diversity of the community served by that school board is key. If you care about issues like police shootings, and unjustified police shootings of unarmed individuals, particularly of African Americans, and caring about your city council is key. City councils allocate funding for police departments and sometimes have a say in police chiefs and whether or not those police chiefs are held accountable for how their police departments are run. If we believe in an inclusive democracy, then we want a democracy in which our local government, our state government, our federal government reflects the diversity of the communities served by those entities. And also, when we have diverse bodies, it helps increase public confidence in the outcomes and in the work done by those bodies. So I'll stop here, but as we get closer and closer to 2020, I think civil rights lawyers recognize that there is so much work to be done, that the 2020 round of redistricting will be like none other. And so I'm excited about the possibility of working with and engaging with all of you in the important work that lies ahead. Thank you.
Did Section 5 of the VRA before only cover African Americans in the South, or did it also cover other marginalized groups across the country, e.g.? And what about the VRA as a whole?
Yeah, that's a great question. The Voting Rights Act protects several historically marginalized groups. There are some provisions of the act that deal, for example, with the unique barriers faced by minority language voters. Section 203 of the Voting Rights Act is a provision that requires that certain jurisdictions with large numbers of non-English speaking voters, it requires that they make materials available that are bilingual. It requires that they make translated ballots available, for example, in Spanish in certain communities. Requires that they hire bilingual poll workers. So there's some provisions of the act that deal with access for minority language communities. And all of the provisions that I talked about, the Section 2 and the Section 5 provision that are used in Voting Rights Act litigation are and have been used to protect and ensure that African Americans, Latinos, and Native Americans all enjoy an equal opportunity to elect candidates of choice.
The Voting Rights Act, specifically minority districts, currently could lead to undesired Democrat packing. Do you see this as a problem?
Yes. Racial and partisan gerrymandering, I think, are two evils that we need to be equally focused on. And in some communities, we see that there is a correlation between race and party that can't be ignored. It's one of the reasons why the case that I mentioned that we filed just a few months ago in Georgia is a case in which we mount racial gerrymandering claims and partisan gerrymandering claims. But, sometimes we are bringing these cases not just in, our work is nonpartisan, I should say at the outset. Sometimes we find that we're bringing these cases in jurisdictions where the white Republicans are the ones redrawing the lines and making the critical decisions. And sometimes we're bringing these cases in communities where there are white Democrats who are the ones in charge. So, I don't think that there is a clear answer to that. I think it really depends on the community. And the reality is that in some places in our country, race trumps partisanship. And that is the primary evil that we are always focused on tackling as a civil rights organization.
The original Voting Rights Act was, as you say, largely the result of the Selma to Montgomery March. How can experts, lawyers, mathematicians, social scientists cooperate with on-the-street activists?
That's a great question. I have been involved in redistricting for 2 cycles now, the 2000 and the 2010 round of redistricting. And, it's difficult doing this work. And one of the things that makes true engagement in the redistricting process so difficult is that communities are often doing this work not armed with people who can really help to marshal data and analyze data and counter the data or maps that have been put forth by the states. So I'm imagining a 2020 round of redistricting that looks a little different. One in which there are people on the ground in communities who are turning out to meetings and insisting that there be a lot of sunlight on the process and insisting that there be real opportunities for community engagement in that process, and imagining a world in which the community is doing that work shoulder to shoulder and side by side with folks like you all in this room who have unique expertise that can be brought to bear on that important work.
You mentioned the grueling case-by-case pace for favorable changes to voting rights legislation and practices in the U.S. Where, if anywhere, do you see opportunities in our near future for more dramatic, quicker, or large-scale change?
One, we need Congress to restore the Voting Rights Act. That is long overdue. And every day, we are bringing pressure to bear on Congress and, urging them to take action to restore the Voting Rights Act. And you all stand to play an important role in that advocacy effort as well. Yesterday, for example, was a day where we used the 52nd anniversary of the Voting Rights Act to urge Congress to take action. But without it, we are in a world where we're faced with mounting slow, case-by-case, costly, complex, time-intensive litigation to fight back. And it's scary to imagine what the 2020 era looks like if that's our only approach and only vehicle for challenging the discriminatory redistricting plans that sadly, but inevitably, will emerge. Even if every single one of us in the room were to mobilize, it's unlikely that we're able to cover the thousands of jurisdictions across our country that will be engaged in the business of redistricting in 2020. Given that reality, I think it's really key, really critical that we continue to push for Congress to restore this important federal civil rights law.
In creating districts, how do we take into consideration incarcerated citizens?
That's a great question. Prison-based gerrymandering is a problem in many parts of our country, and there are a few states that have tried to respond to this issue. What we have in some states in our country is a reality in which people who are detained in our jails and prisons are incarcerated in communities that are not home, and incarcerated in communities where officials don't consider these inmates their constituents and could care less about them, frankly. But because the census tends to count those individuals where they are held on census day, the reality is that this sometimes falsely inflates or artificially inflates the population of many rural communities that tend to be the places where people are jailed and imprisoned. There's some states that are responding to this. New York is one example. In New York State, the reality is many people are detained upstate. We have a prison population comprised of a disproportionate number of blacks and Latinos because race infects our criminal justice system at every stage. And what New York has done is required that legislatures reallocate those inmates to their home communities. And many of them consider home and deem home and will return to their home downstate once they are released. This is a reform that we need all across the country. There's been a push to also get the Census Bureau to count those people in their homes, their true homes, and not where they are held on Census Day. And so far that effort's not been successful, but we're continuing to mount that fight and at the same time pushing states to put in place solutions to help deal with the effect and the racial impact of prison-based gerrymandering.
What tools or data do you wish existed to help better understand and challenge racial gerrymandering?
Probably a computer program that could do all the work that you all are able to do in this room. I know there's going to be training around GIS, geographic imaging systems. But yeah, just a way to more quickly assess the impact of proposed redistricting plans would be key. But you know, I also talked about other kinds of voting changes. Texas's photo ID law, North Carolina's cutting of early voting hours, because all of that work requires the expertise that many of you all have in this room. I skipped past this slide, but this is a slide that breaks down the impact of North Carolina's early voting changes on African Americans in the state of North Carolina between 2012 and 2016. If you look at the far right, you'll see that there's been significant decreases in the number of African Americans who have turned out during early voting between 2012 and 2016. The average drop statewide is 9%, but in some communities like Robeson and Hanover, we've seen drops that exceed 20%, 25 in Robeson and 22% in New Hanover. This is a chart that shows the number of African Americans who are without qualifying photo ID in Texas vis-a-vis other groups. You see that 25% of African Americans are without a form of qualifying ID vis-a-vis 8% of whites. But having the ability to turn out this kind of analysis would greatly facilitate the work of civil rights lawyers. And we don't want to be able to do this analysis after the fact. We want to be able to do this analysis well before that, when these laws are first put forth and put on the table. So that's something that I think would greatly facilitate our work that we're doing to safeguard access to democracy and to fight back, really engaging with folks a lot earlier in the process so that we might help prevent some of these laws from ever being put on the books in the first place.
Thank you so much.
All right, thank you.